The clerk will open the court.
Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
We'll hear argument this morning. First, in 1962, Odyssey 2020 Academy against the Galveston Central Appraisal District from Galveston County and the 14th Court of Appeals District.
May it please the court, Mr. Hoffer will present argument for petitioner. Petitioner has reserved 5 minutes for rebuttal.
May it please the court. Odyssey Academy, like many charter schools in the state, lease property for school facilities. Charter schools lease property for a number of reasons. For example, the state does not provide initial startup funding for facilities, or they may not have adequate credit to secure favorable loan terms, or there may not be adequate facilities available in a location that the state has authorized them. In this case, Odyssey Academy owns fee title to most of its campus on Galveston Island. And for the portion that it holds fee title, the Galveston Central Appraisal District has, in fact, granted exemption. However, there's a portion of its campus that it was not able to purchase, and it entered into a long-term lease through a sublease arrangement. HEB ultimately is the owner, and there are 2 LLCs that sublease to Odyssey Academy. That lease is paid for 100% with state funds that Odyssey Academy receives under 12.106 and 12.107 of the Education Code. And the landlords have approved of the structure. The lease is limited to operation of a public charter school, and the lease requires that they comply with all statutes and regulations governing public charter schools. Odyssey asserted its exemption for that leased property, and the Galveston Central Appraisal District denied the exemption. And the result is that Odyssey Academy has to take the state funds it receives that are public funds held in trust from the state, and then pay taxes on those very state funds to other local governmental entities. This creates a clear inefficiency that runs afoul of the constitutional requirements that the public school system and its financing be efficient. This court in Combs versus Rourke Amusement Vending from 2013 said, "We believe in the area of tax law, like other areas of economic regulation, a plain meaning determination should not disregard the economic realities underlying the transaction in issue." This court also recognized the futility of a governmental entity taxing itself. In Lower Colorado River Authority versus Chemical Bank, this court said, "The government in Texas could engage in the senseless process of taxing itself, the net result of which would be but to take money out of one pocket for the purpose of putting it into another, less the cost of assessing and collecting the tax. Obviously, this court recognized that procedure could never accomplish anything but an idle expenditure of public funds." While the Court of Appeals—
Mr. Hoffer, may I just ask you a question?
Yes, Justice.
Does the lease in this case really matter? That is, does it matter whether the owner of the school is responsible for paying the property taxes? So does it matter that a private owner that leases its property to a charter school and retains responsibility? Let's say if you didn't have the lease that said that the school needed to pay it, then would that property owner still get the benefit of the tax exemption because of what you're talking about, the public nature of what's going on?
Yeah, it's our understanding. First, in this case, the lease requires that the charter school pay the rent. Right. And probably the vast majority of commercial leases, the tenant has to pay the taxes. That's very common in practice. However, if the landlord somehow reserved its obligation to pay the taxes and said, charter school, you don't have to, we'll pay the taxes. First, I would counter that most likely the rent is increased to include those taxes, so that in effect, the charter school is paying the taxes through rent. In this case, like in most cases, because landlords do not want to recognize rents that are really expenses because expenses are deductible, they carve it out as a separate matter.
So, Mr. Hoffer, you're paying the owner's property taxes, right?
That's correct.
Okay. Your property interest is not being taxed, your leasehold interest.
Well, we, under 12.128 of the Education Code, we have two interests, in fact. The legislature has said that there's a leasehold that is public for all purposes, but also the statute imposes a trust. And that trust, we believe, creates equitable ownership and beneficial interest in the beneficiaries of the trust, which are the public school students.
So, but wouldn't that be an equitable interest in the leasehold, not in the underlying ownership of the property?
Well, the statute's not clear. The statute's very broad. In fact, the statute says that property that is leased with state funds is public property for all purposes, is property of the state, and is held in trust for the benefit of the students. So,
Mr. Hopper, that's
Yes.
what's a little troubling. The burden is heavy and you must clearly fall with an exception. And it seems like you don't. And that makes your argument troubling. Can you address, the clarity with which you are required to establish the exception?
Yes, Justice Giesman, thank you. So the Texas Constitution, specifically for schools, in Article 8, Section 2, actually is very specific in that the legislature was allowed to grant any persons or associations of persons that are coming together for the purpose of owning and operating a school tax exemption. So we have the very broad potential in the Constitution of persons or associations of persons coming together to operate schools. This harkens back to the days where towns and ranchers and farmers would come together and do a school raising. Well, in the modern concept, in this era, we have a lease. We have a landlord, in this case, a landlord and a sub-landlord and tenant coming together for the purpose of operating a school. So when the Constitution allows these association of persons to come together, and we in fact have come together under this lease, and the parties have recognized that they are subject to the laws and rules governing charter schools, that under 12.128, the legislature said that this leasehold and this property are placed in trust for all purposes under state law for the benefit of students. And it's property of the state. So the leasehold and the trust and the interest in this property are converted into this special trust property. And at that point, Odyssey Academy says, well, if this is property of the state for all purposes under state law, that includes the tax code. And so when the legislature says all purposes, they mean all purposes. And the jurisprudence suggests that that is a very sweeping edict from the legislature, but it means what it says. And that creates an entitlement, we believe, under 1111 to tax exemption. Because ownership in the tax concept in the tax world is not clearly defined. The court has recognized that ownership in property tax cases can mean many different things, that it's not limited to fee title, that it can include equitable ownership. And frankly, in the past cases that the courts have dealt with, equitable ownership has been defined as the present right to compel title. And there are other cases working up through the courts where equitable title is the primary issue. Here, equitable title.
Do you have the present right to compel title under this lease?
Justice Busby, we do not have the present right to compel title under this lease, but we're instead positioning that we don't have equitable title through the present right to compel title, but we have equitable title because the trust creates a beneficial and equitable interest in the students that the landlord and the school have come together and agreed to, and that creates a different type of equitable title.
Well, and I understand your argument on that, but why wouldn't that be an equitable title in the leasehold rather than in the underlying ownership of a fee interest in the property?
So it certainly is an equitable interest in the leasehold. There's no doubt that it is that. But the legislature in 12.128 said that it is public for all purposes under state law and is property of this state. These are very unusual terms for the state, for the legislature to say that this property becomes property of this state. And then it creates.
I understand your argument on that, but it seems like you could give meaning to those words by saying that the leasehold interest is public for all purposes and that the leasehold interest is property of the state without somehow depriving the owners that have the fee interest in converting their interest into something that's public.
Well, one, we don't disagree that it is a public leasehold interest, but we believe that it goes beyond that and that the equities align and that we want to avoid the futility of taking the tax dollars that are held in trust that are paid to Odyssey Academy. Then Odyssey Academy doesn't own the money. The money belongs to the state. It acts as the trustee on behalf of the state the entire time. And we want to avoid the futility of then taking those tax dollars and paying it, the majority of which through property taxes goes back to the school district where the students left and they've come to Odyssey Academy. So it takes money that has been legislatively provided to Odyssey Academy away from the very students it was intended to and back to a school system that is no longer serving them. And we believe that that is just inefficient.
Oh, go ahead, Justice Bland. Okay. I was just going to ask, are there any consequences that might flow from holding in the way you would like the court to hold? I understand your argument in this context, but does this have any consequences for other types of entities?
I don't believe that it does, because we're operating under a very narrow constitutional scheme that only applies for schools specifically, not other types of public entities, but schools. And then we're operating under 12.128 of the Education Code. And there aren't many, if any, other statutes that say for all purposes under state law, we don't have that for other private entities or private actors that I've ever seen. So I don't believe it'll have any unintended consequences. It's a very narrow result specific to charter schools, which is what the legislature intended.
And to that end, if you are looking at the Education Code and the specific provision, it says property leased with funds received by a charter school. And so, leaving aside, say we don't agree with you that it creates any kind of legal or equitable interest in the property itself, does 1111 say that, 12.128 say that the property, as opposed to just the leasehold interest, is treated as public property. So in other words, property there means property in its entirety, not just the leasehold interest, because it's property leased with funds. It seems as though that's a narrower view of everything than sort of this grand public trust that would impinge on private property owners' rights in the fee title.
I agree. The statute is specific to the property. It says the property leased with funds received from the state under 12106, so it's limited to state funds. And here the parties have stipulated, and there's no issue that this lease is paid for with state funds. It would not go beyond that. In fact, I would say if the charter school used non-state funds to pay the lease, if it used private philanthropy to pay the lease, then we wouldn't be here.
If we read it that way, Mr. Hofford, go ahead, Justice Boyd.
I'm sorry, Mr. Hofford, does the Academy have a choice as to whether to use state funds or donated funds to pay the lease?
In this case, the Academy's funding is the vast, vast majority, in the high 90th percentile is state funds. They don't have a lot of philanthropy.
Right, but if it did, if some alum came along one day and donated millions of dollars so that the school had the option, or so the school had the wherewithal financially to use philanthropy funds, would it have its own choice as to whether to use those funds to pay for the lease as opposed to other things?
I suppose it might, but the charter school has to not commingle private monies from state monies. The law requires the charter school keep clear and discrete records and separate accounting for private money and state money. And so if it were to do that, it would commingle it. But if it would have to pay it 100% from non-state funds, it would have to pay it. If it's commingled at all, then it becomes property of the state under 12.128.
Is the Academy exempt from paying sales taxes on equipment and supplies that it purchases?
Yes, the Academy and all charter schools are exempt from sales tax.
Mr. Hoffer, if we were to read the statute to say 12.128 to say that the underlying property is public, does that violate Texas Turnpike by saying that because there we held, the ownership has to be based on facts. The legislature can't just deem you the owner of something that you don't actually own. So how would that reading intersect with Texas Turnpike?
So Texas Turnpike says that the ownership must be based on fact and circumstances, and that the legislature can't just by edict declare ownership. But in this case, we have operative facts that support beneficial and equitable ownership, because the parties through the lease have come together and agreed contractually that they're going to operate a school, and that they're exclusively going to operate a school. The lease says it shall exclusively be used for the operation of a public charter school, that it shall be done in accordance with all laws and regulations affecting the charter school. And the parties take this trust knowing what the law is. So the operative facts here are a little bit different than Texas Turnpike. In Texas Turnpike, the parties agreed, well, one, the ownership had to remain in the private entity, and the parties agreed to escrow title without delivering it. So they never delivered title. And I see my time is up.
Any other questions? Thank you, Mr. Hoffer. We'll hear from the respondent.
May it please the court, Mr. Brown will present argument for respondent.
May it please the court. I think from the justices' questions, it's clear to them that they recall the court's opinion in Willacy County Appraisal District versus Sebastian Cotton and Grain, a 2018 opinion at 555 Southwest 3rd 29, which has an excellent discussion of how the legislature has implemented a property tax system in Texas in which owners are taxed, and it's based on ownership. To quote from that court, a person who property tax liability therefore derives from ownership of the property. A person who owns the property is generally liable for taxes assessed on that property, and a person who does not own property generally has no property tax liability. And that's the case here, but for Odyssey's sublease with H-E-B grocery store. H-E-B leased from two private LLCs. Court of Appeals opinion reflects they're Delaware LLCs based in Florida, and they are receiving rent from H-E-B, which inures to their private benefit today. And to the extent the rent Odyssey pays to H-E-B, to the extent it exceeds the rent due under that main lease, H-E-B is benefiting from this lease arrangement. Both are obviously benefiting from the obligation Odyssey assumed to pay ad valorem taxes under the term of the lease. I'll agree with opposing counsel that in a commercial lease context, certainly, and probably in all leases, if a tenant isn't paying taxes directly, it's going to come up somehow and figure into the amount of rent they pay. So it's a fact of life in terms of leases. The legislature has not just recognized or contemplated that, it has expressly authorized it. Odyssey has used its funds with the authority granted charter schools under 12.107. It incorporates section 45.105 of the Education Code, which gives school boards broad discretion to make expenditures in connection with renting the properties.
Mr. Brown, do you think the legislature intended for public funds to be transferred from one government entity to another? It seems like that's doesn't make a lot of sense.
Well, I think the court's opinion in Morath discussed a number of issues regarding school finance that people could take issue with, but the court ultimately held correctly. It was their decision. In 2017, the legislature amended section 12.106 of the Education Code, which to provide limited facility funding for charter schools. And in it, the legislature expressly said that those funds could be used for certain purposes, including, they identified rent and property taxes. So the legislature has expressly authorized charter schools to pay property taxes. It's very unusual, but this is an extremely, as this court is well aware, an extremely complex financial system. For example, in its reply brief, Odyssey talks about how absurd it is for Odyssey to have to pay taxes that go to the Galveston Independent School District. Well, that's not the case. Galveston Independent School District is property wealthy under what is now Chapter 49, after House Bill 3, used to be Chapter 41. All this decision does is affect how much is paid to the state under the Robin Hood component of school finance so that it can redistribute it to other places. So there's a whole lot of moving parts and to this system, and the legislature has clearly decided that in this instance, it's appropriate for a charter school that pays rent to a private landlord and who agrees under its lease to pay property taxes, that it can pay them. And so it's, again, none of us in this proceeding today wrote the system. It is what it is. It's what the legislature created.
Mr. Brown, just looking at 12.128, you would read property leased with funds received by to mean leasehold interest. In other words, you would limit the definition of property there to leasehold interest. And is that consistent with the rest of the statutory language? And why wouldn't the legislature say only your leasehold interest is deemed to be public, rather than saying the property paid for with leased funds?
Well, first of all, yes, to answer your first question, I think the 12.128 provides that property that a charter school purchases is the fee interest is public property in that instance, if state funds are used. And that when it's leased, the leasehold interest is public property. The legislature has already provided in section 25.06 of the tax code that leaseholds, public or private, are not taxed. It need not do so again here. The problem I have with Odyssey's argument is its breadth. As much as they try to limit it to the context here, what they're saying is that it becomes public, the taxable fee, in order to be exempt, has to become public property for all purposes, not just for ad valorem tax purposes to create an exemption, not just for the term of the lease. It doesn't say that either. It is effectively, under their argument, public property for all purposes, and the fee owner is effectively divested of title if you carry this argument to its logical conclusion.
Is the fee owner divested of title or protected under state law with the protections that are afforded to schools? In other words, it becomes school property for purposes of remedies under the Civil Practice and Remedies Code and lawsuits and all kinds of things. So is it protection or is it divestment?
Well, I don't, a private owner being entitled to immunity under sovereign immunity or under the Tort Claims Act, perhaps, just seems, I can't see, it's not in the language. It's, but it's basically, if it becomes, if it's public property, it's no longer private property. So it just makes no sense. And the statute doesn't say that, and further, it's reinforced where subsequent subsections of 12.128 expressly state that the state does not take the fee if a charter is revoked. It has the right to have the lease assigned to the state if it chooses to do so. So it recognizes that it's a leasehold interest when property is leased by a charter school. So,
Counsel, I certainly understand your point that if it were treated as the state's property for all or public property for all purposes, that would interfere with title and there might be constitutional problems with that and with implications of taking that to its logical extreme. But wouldn't one way of approaching this be to ask whether each application of the idea that this is public property has to be tested against the Constitution, and the applications that are constitutional as a property tax exemption might be, pass muster, and the applications that are not, such as divestment of title to private property, those obviously would not be applied, but we would apply the for all purposes language to the greatest extent consistent with the Constitution. Why wouldn't we look at it like that?
Well, theoretically, you certainly could, but that's quite an extended analysis under a statute that says nothing to that effect, which is under the court's prior precedent is supposed to be strictly construed to determine whether or not it grants an exemption in this context.
Brown, if we did that, would we have to also test the statute against Article 11, Section 9, which says that the property has to be owned?
Correct. And this court's cases have said property has to be owned, and I've never really understood the argument that appeared under Article 11, Section 9 for the first time in briefing to this court. But this property today is being used by its private owners to generate rental income that they receive for their personal use and benefit. To the extent there's an additional amount that HEB gets, same thing. By definition, this property is not being devoted exclusively to the use and benefit of the public under Article 11, Section 9. And that's why, going back to Texas Turnpike, courts have held that public ownership, well, before that public ownership is required under Article 11, Section 9.
Does Article 8, Section 2 apply to real property? I know there are some discussions of buildings and other things in there. It wasn't clear to me what from the language, if you can just exempt real property from taxation under Article 8, Section 2, if it doesn't have an improvement that's being built on it.
It does not say that, or it talks about school buildings, but it also has an ownership component in the language. And this court has not, well, this court has analyzed that language but in some older cases, and this argument was raised in Odyssey's reply brief talking about that portion of Article 8, Section 2. So forgive me that it's not in our brief, but the current exemption the legislature has implemented pursuant to that provision, Justice Busby, is Section 11.21 of the tax code, which clearly requires ownership. But the prior statutes under the revised civil statute pretty much exactly track the language that you just referenced in Article 8, Section 2. And this court interpreted that language in Red versus Morris, 10 Southwest 681, an 1889 decision, and did so again in the case Smith versus Feather, a 1950 decision of this court in 234 Southwest 2nd 418, both of which said, looking at statutory language that tracked exactly that constitutional provision, public ownership was required. So some of these arguments have come up more recently, in fact, after our briefing was completed. So I just did want to note that.
So, Mr. Brown, if we agree with you that the leasehold estate is the only estate that the property that 12128 can refer to, because it's the only piece of property or property interest that the charter school acquires, does the fact that the leasehold estate is burdened by being responsible having to pay the property taxes mean that, at least for the purposes of the leasehold estate burdened by those taxes, it's entitled to an exemption? The charter school is entitled to an exemption.
Well, the statute does not say that. And the legislature has expressly said that contemplated and authorized them to pay the taxes under 12.106 F2 and 45.105C. This court has previously looked and analyzed fairly recently an exemption contained in the education code itself. Texas Student Housing Authority versus Brazos County Appraisal District in 2015, 460 Southwest 3rd, 137. The court analyzed section 5.3.46, which dealt with student housing authorities in the higher education component of the education code. And it expressly said that these facilities are exempt from taxation of every character. When they say it, when they intend it, they say it. In contrast here, we have this broad language, which makes perfect sense, you know, if a school, and it's whether it's a school district or a charter school, if they lease their copy machines, people can't go use those to run copies for their own personal business. It's state, it's state funds are used, it's state property, it has to be used for public purposes. That's what the intent of this statute appears to be, that state funds have to be used for authorized purposes, and that the property, whether it's a leasehold or a fee, if it's property that's purchased or leased with state funds, the state has the right to take it back if the charter gets revoked. So that's my take on that. And it's interesting in this case, Odyssey, despite that burden, has apparently, well, it's done well. I mean, the last year, of course, the rankings came out was 18-19, but they're a B school under the state system. Apart from that, they originally leased the entire 6 acres that their campus is located on. And the lease, the sublease incorporated 2 master leases. One is the one with the private LLCs. The other was surrounding property, and they acquired the funds and purchased that other property. So they own more than half now. And that, of course, the appraisal district, without incident or opposition, granted the exemption because they're clearly, it's not disputed, the arm of state government, that they're a political subdivision and that they qualify when they have the fee. Well, if they have legal or equitable title, they qualify for an exemption. Here, they have a lease that ends in 26. In fact, it expressly disavows any option to purchase in this case. So that's what distinguishes this one.
Mr. Brown, do you know if the issue has come up with other appraisal districts?
Well, it's interesting. It apparently has, and I saw some of the concerns raised by the amici in this case, but again, this is very recent. December 29, 2020, the Dallas Court of Appeals issued an opinion in Dallas Central Appraisal District versus International American Education Federation, rather long name, holding that they had equitable title and therefore were entitled to an exemption as public property, citing the 14th Court's opinion in this case. So I don't see any implications. I think going forward, the court's going to have cases come up that try and define, as people challenge and the law evolves, on what equitable title is. We've got, the present right to compel title and some of these other sort of black letter type statements from opinions, but it's equitable. And so people are going to, that may be litigated. The solution would be if the legislature would define ownership in the tax code, but Until that happens, this court will have to do the best it can to define that. But it's not an issue in this case. They, as opposing counsel duly noted, legal and equitable title does not apply in this case.
So just kind of help me think through, from your perspective, how we construe 12-128, which says property leased with funds by a public school is public property for all purposes, and 12-106F2, which says money given to a charter school can be used to pay property taxes, ad valorem property taxes. Those two seem to conflict to me. On the one hand, there's no need for them to pay property taxes if the funds are used to lease. So is there some way to construe those two so that both have meaning?
Well, yes, and I think it goes back to some of the questions Justice Busby and Justice Guzman asked early on. Property means the leasehold estate when property is leased. That's the public property that's public for all purposes. The issue, however, the legislature has recognized that in the modern world, without funds or the ability to issue bonds and build buildings the way school districts can, the charter schools are going to have to lease property. And in those instances, commercial landlords are often going to require the payment of property taxes. And that's why they authorized it in the facility funds, as well as the general language in 45.105.
Any other questions? Thank you, Mr. Brown. Mr. Hoffer, I believe you have 5 minutes.
Can't get my camera back on. I don't know if. Can you all hear me and see me?
Can't see you, but we can hear you.
All right, it says my video is running, so I will, there we go. Okay.
There you are.
I'll address 12.106F briefly for Justice Boyd. When that was added into legislation, the litigation was really in its infancy. And the fact is that the charter schools under the leases are required to pay taxes. And there's no ability to avoid penalties and fees and interest under the tax code. And so because we didn't know where litigation was going to go, we asked the legislature to authorize the payment of taxes, but it's an option. It says the charter school may pay property taxes. It doesn't create a requirement. It doesn't impose a tax. But for example, in this case, Odyssey has paid the taxes under protest, subject to its exemption assertion. And charter schools throughout the state have in fact done the same, as they are appealing and requesting tax exemption. In addition, when we pay under protest, we avoid those penalties and interest, which cannot be waived. So if we were to lose the case and not have paid the property tax, then the charter school is going to have an additional significant penalties and interest that it incurs. But 12.106F does not itself create a tax obligation. It says the charter school may pay the tax. Moving to, is there other litigation pending in the state? We are counsel for the other litigation in the state, and IL Texas International American Education Federation did prevail at the Dallas Court of Appeals. In that case, they had a lease with a purchase option, and so they had equitable title, and the Dallas Court of Appeals agreed that it was therefore entitled to tax exemption under 12.128 and 1111 of the tax code. That opinion, I believe, has become final, and the appraisal district has not appealed it. However, there's similar litigation pending at the 13th Court of Appeals, where the Cameron Appraisal District has denied exemption, where the charter school has equitable title because it has a purchase option. And there's also litigation pending at the Tarrant trial courts now on the same exact issue. In fact, for two separate charter school systems with nearly identical lease structures giving them purchase options, which is another reason it's important that this court clarify that 12.128 in conjunction with the level of the tax code can in fact give a tax exemption where there is equitable title under the court's recognized doctrine of a purchase option or other present right to compel title creating exemption. So we want to make sure that's preserved, and the Dallas Court of Appeals has agreed. Another issue that's come up was, is there a divestment of title? And we believe the answer is no. There's no constitutional issues here with divestment of title or takings issues here, because the parties have agreed and come together knowingly subject to the law of 12.128, and they've been given fair compensation. They've agreed to transfer whatever property interest they have into this trust estate, and they've been fairly compensated, bargained for consideration through the rent. And so that avoids, we believe, any divestment of title and any takings analysis of the Constitution. And once the lease ends and the school's no longer there, they get their title back. So the trust ends at that point once the lease ends, and title is not, in fact, divested. Willacy County.
Sorry,
Yeah.
go ahead.
Go ahead, Justice Bland.
If the property is public property for all purposes and not just the leasehold interest, if the lease, it ends, as you said, and it goes back to the owner in 25 years, could the state unilaterally say, well, it's public property, we're going to extend the lease for another 25 years?
The state could say, if the lease gave the state an extension option, then the state under 12.128, they have the ability to step into the lease. And if there was a benefit, they could step into the lease and exercise their right to extend. In this case, there's no automatic right to extend.
Mr. Hoffer, what's your view of the property that's being leased under 12.128?
The property,
what's being leased?
what is being leased?
Yeah.
Well, it's actually kind of a wing of a shopping center. If you picture an old shopping center and you got the wing and where the other little small stores are, that's what's being leased here, and it's classroom space.
Right, but is what's being leased the fee interest or the leasehold interest?
Well,
The
we're
right to
leasing,
occupancy and that kind of thing. What type of property is being leased, in other words, in terms of, fee simple, the different categories of real property that we have?
where we are getting the full bundle of sticks in terms of quiet use and enjoyment of the property, exclusive use of the property for the school. That's what the lease gives us. So
For a stated term.
That's correct. Through 2026, in fact.
And the obligation for you to pay taxes is contractual, right?
The lease requires that we assume the burden of the taxes.
Okay.
And I do agree with Justice Bland that 12.128 protects the landlord. It gives them immunity. It encourages them to lease to a charter school, because why would you lease to a charter school when you would assume the liability? The charter school's got sovereign immunity and you don't. And so this gives them the ability to assert immunity as well, because they're serving a public purpose. And I see I'm out of time. Thank you.
Any other questions? Thank you, Mr. Hoffer. The case is submitted and the court will take a brief recess.
Thank you.